The Chief Justice, Her Ladyship Gertrude Tokono, this week there's a letter that became public, a proposal for the appointment of some 5 judges to the Supreme Court. In fact, when this letter was publicized this week, in fact, that's what, for our viewers on TV3 and also on Facebook, that's on the screen right now. The details are read for our listeners on radio. I write to respectfully request the following judges be appointed to the Supreme Court of Ghana. Her Ladyship Justice Angelina Mensah Homea, His Lordship Justice Eric Cheiba, for His Lordship Justice Edward Amuakwa Sante, Her Ladyship, I beg your pardon, Justice Pamela C.A. Granting, and Her Ladyship Justice Efia Sariboche. That last name is the trial judge of this ongoing ambulance case. And to the extent that these names were proposed by the Chief Justice when this trial is ongoing, is also another matter that has also been derived as a result of this. Plus, the fact that the Attorney General, who is a major subject in this ambulance trial, is a member of the Judicial Council who should have been the ones also sitting and making this proposal and not a direct request from the Chief Justice. So it's all of this that many have seen as wrong, unethical, unusual on the part of the Chief Justice. In fact, Professor Kwekwaza has written quite lengthy on this, and will show portions of the argument that he raises, specifically referring to Article 1442 of the 1992 Constitution. Let's put that on the screen for our viewers. Article 1442 of the 1992 Constitution. Let's read that and establish exactly why this is unusual, this is strange and concerning, to say the least, in jurisprudence. Article 1442 says that the other Supreme Court justices shall be, quote, appointed by the President acting on the advice of the Judicial Council in consultation with the Council of State and with the approval of Parliament. There shall be a Judicial Council which shall comprise the following persons: the Chief Justice being the chair, the Attorney General, a Justice of the Supreme Court, nominated by the Supreme Court Justices, a Justice of the Court of Appeal, and then also a Justice of the High Court, 2 reps of the Ghana Bar Association, a rep of the Chairman of the Regional Tribunals, a representative of the lower courts or tribunals, and the head of legal directorate, goes on and on. Subject to the provisions of this article, the power to appoint persons to hold or act in the judicial office shall be vested, subject to the approval of the President in the Chief Justice, acting in the advice of the Judicial Council. But essentially, it is the 1442 that there's emphasis on, that the Supreme Court Justice shall be appointed by the President, acting on the advice of the Judicial Council. Do you, in reading the details of this letter that was addressed to the President on the hand of the Chief Justice, you get the sense that this is a collective view of the Judicial Council?
Not at all.
What we have seen?
Not at all.
Why is that?
No, I don't get it. And I'll be very surprised. I think the Judicial Council would have its own letterhead. Yes. Mm-hmm. The Judicial Council must. But this letter is on the letter of the letterhead of the Chief Justice. Yes. So that puts it miles apart from a collective decision of the Judicial Council. Besides, the NDC held a press conference where they gave further details that they have confirmation that the Ghana Bar Association, the leadership, confirmed to them that they opposed the proposals made by the Chief Justice to the Judicial Council. So it was shut down. It was shut down. So quite clearly, and so far, the judicial, or let's say the Chief Justice has not come out to deny these allegations. So I take it that for now, we can go with the statements that the NDCs made, that the Ghana Bar Association refused, and among others. So let's say collectively, as a judicial council, they shut down the proposal,
of these 5 names.
Yes, yes. So that is.
But what is odd and strange and unusual about this?
Okay, so odd and strange and unusual about it. Number one, there is a case of the Ghana Bar Association, Nene Amegache and others versus Attorney General. That case was in 2016 Supreme Court of Ghana Law Report. That's for the lawyers, those who want to read. 2016 Supreme Court of Ghana Law Reports, Volume 2. Starting from page is 872 to 898. So you find that in that particular case, the Supreme Court held, so the date it was held, the decision was on 20th July 2016. That was the election year, right? Good. So in that decision, what the Supreme Court said was that, look, there's been a long-standing practice that in order to activate or in order to set the ball rolling for the appointment of Supreme Court judges, the practice has been that you have nominations from the Ghana Bar Association, 1. Then you have nominations from the Chief Justice, 2. Then you also have nominations from the Attorney General. But all these go to the Judicial Council. Please, this is where the most important fact is. Meaning, in other words, to set the ball rolling, the recommendations must come from the Judicial Council as a body. So what you find is that the Chief Justice's letter going to the President is not law.
It's not law.
It's not law, at least going by this decision. Because, it's the Supreme Court that explains the provisions of the Constitution. Because this was the one in which Puaman and others, yes, Justice Puaman, their appointment and etc. So the Ghana Bar Association wasn't happy. Sometimes when I sit back, you go back, you read Daily Graphic, front page, Justice Amegache, later he was appointed to the Supreme Court. He was vehement against it. No, it's politics, Later, he himself, it's a political party that he's hard to come.
That took him there.
Because his boss is Okujeto. And so, listen, Amegache cannot run away from the fact that it's for Okujeto that he got appointed to the Supreme Court, right? So when he was... Okujeto is MPP. So the time Amegache was going through the process, I said, you see, a few years ago, front page, Daily Graphic.
No, it's supposed to put a mind going. Exactly. So put a mind's appointment delay like a year.
You see, it's a small world there. It's a small world, she said. Okay, so the Supreme Court says in this GBA Amegache case that take your nominations to the Judicial Council, even you, Chief Justice, take your nominations to the Judicial Council. Then the Judicial Council will go through, they have their own internal process about vetting the nominees. When they are done, then they recommend to the President. Can we have 1442?
Yeah.
Let's read it again. 1442, can we read it again? You see, so no matter what you do, to be able to properly invoke the powers of the President to appoint, there must be a recommendation from the Judicial Council. So it's difficult to see how the Chief Justice's letter can kickstart. So it says that 1442, the other Supreme Court justices shall be appointed by the President, acting on the advice of the Judicial Council. So we'll leave out the Council of State Matters, blah, blah, blah. But you see, this is how it starts. So if the President has not received any advice from the Judicial Council, he cannot start. So I try to think about it that, so maybe, these kind of things, could it have been that, yes, if the Chief Justice wanted to do, but even in this case, the facts are showing, there was a publication in the Daily Post, and then the NDC press conference. It's saying that the Chief Justice earlier on went to the Judicial Council and it failed. So I don't know whether this was a last-minute charm.
A backdoor approach.
But please, from the decision I'm reading here, that backdoor too cannot work. Because they are saying that that's been the practice through the Judicial Council. So a Chief Justice cannot write to the President, and then the President will now, because the President can't do it without the Judicial Council. And, quite apart from that also, the timing is very bad. Yeah, the timing is bad. The optics are not good. Akufo-Addo has barely 5 months to leave office. we should not give him another opportunity to make a decision, as momentous as appointing Supreme Court justices. No, he should wait. Let the new president come. Besides, number 3, when you read the GBA case, the Supreme Court itself said that, listen, there's been the convention that their number is never gone beyond 14. Yeah? Yes, you hear Tuguba.
Same decision.
Yes, it says that their number is never gone beyond 14. As far as I'm aware, currently they are about 15, right? So why are 15. Why are we adding more? And I appreciate that, yes, there's an overload of cases in the Supreme Court. I appreciate all that. Yes, I have cases that I wish they were called.
In fact, that's one of the reasons that the Chief Justice gives, that you admit that there are so many cases for the Supreme Court to hear.
Yes.
Let's play that short
as you look for it. Let me make this point.
By the Chief Justice.
But Article 125 makes it clear that justice emanates from the people.
Okay.
So it shouldn't be a decision for the Chief Justice alone. No. It's not an autocracy. Let's have a national debate. Oh, people, look, we ourselves in time past, we've said that the convention is that we've never gone beyond 14. And this 14, let's know that it's not only in Ghana. If in our African peer review mechanism, it went there. You know, at a point, the African peer review mechanism under President Kufuor's regime, when they were such, we've had this debate. This is not the first time we are debating these numbers. So the African peer review mechanism, they even came back when Kufuor submitted our report. They came back that we should legislate, right? And then at that time, we heard in the news, the debates that were going on, that, we reckon that by convention, we don't go beyond 14. So if, for any reason, we now think that, no, we'll go beyond 14, and I don't have a problem with us going beyond 14, because as long as it helps in efficient justice administration, I'm for it. But it's the manner in which it's being done, secretly, the Chief Justice alone writing to the president, no, Ghana belongs to all of us. Let's have a debate, let people weigh in, lawyers and non-lawyers, then we will see the wisdom in it. But where you just have the Chief Justice alone writing to the president, no, that's not how it's done. It's a democracy. Article 125 says justice emanates from the people. So if in times past we've said we've never gone beyond 14, and now we see wisdom in going beyond 14, let there be a national discussion. Let there be a national discussion. Let people weigh in, especially the non-lawyers. Yes, sometimes you sit down, you think you know it all. A non-lawyer or lay person opens their mouth and you see that, oh, listen, they've said, you had never even thought about it, right? And the last point, the fact that the trial judge in the Jakpa case is also on the list. Justice Efia Sewa, you know, she's a fantastic judge. Of course, we have this being human, it cannot be all perfect. But today I'm not talking about those issues. So for this purpose, fantastic. But once it's come out that Jakpa says in his tape that Attorney General says that things have been arranged. Things have been arranged. Hey, and in Ghana here, the Attorney General is telling you that things have been arranged in a trial. Naturally, you would think about communication with the judge, etc. We can't shy away from this. Let's be very open, right? Otherwise, our democracy will not grow. So when I saw the list, I said, hey, then is that part of the things have been arranged? There will be suspicions, and I'm not the only one. Even in the Ghana Bar Association, the Supreme Court itself recognizes it. You see Atuguba talking about it, that people have always been skeptical, etc. Not once, not twice, more than 3 times. He quotes from Justice Dr. Dateba's book. Let me read a little bit about it. He says, listen, this long-standing skepticism of the independence of the judiciary, and now the Supreme Court in particular, led to the issuance of the following practice direction, blah, blah. So they've always been suspicious. So at some point in time, Justice Redu said all of them should sit, all the Supreme Court justices should sit on constitutional cases, or minimum of 7. Then later, another, was it Wood, who came and said, then at least 9. We are not able to do 9. We do 7. I think they will do 1. Then you go on. So Atuba, his opinion is laced with so many quotations showing our history, the way Kwame Nkrumah made the judiciary very pliant, right, etc. So they trace our history and you see that citizens have never trusted the courts. That's it. It didn't start today. Yes, they will quote and quote and quote. right? Look, you go to page 885. This skepticism, as noted at pages 48, 49 of Dr. Dateban's formidable book, Reflections on the Supreme Court of Ghana, blah, blah, blah. Then he go on. So you see that Dateba also mentions, states the point. So what we're saying is that we're developing the point about Justice Asaribuchi being on the list. So when I saw a name, I said, yeah, this is...
Especially when the trial is ongoing.
Exactly. I said, this why it will just feed into the suspicions. And you follow debates and you see people saying it all over that, we knew it. You see, it's unfortunate. So maybe all of this should have informed the manner in which this was done. That, look, let's shelve it for now. You remember President Obama in 2016 when he was leaving, he wanted to appoint the current Attorney General, Mary Garland, to the Supreme Court. The Republicans told him that, no, this is an election year. It's too late. It's too late. So Garland didn't make it. So, I mean, please, the time is too late. At least, but you know that 2 have been approved. Justice, 2
out of the 5.
No. They are not there. They are an additional. Frimpong. It's Frimpong on their 5.
No.
Frimpong, Justice Dr. Frimpong,
and then
he's not on the 5. Benasco Issa. So I understand 2 have been approved. So they will soon be. They will go through. They are not on this list.
This is not.
Yeah. So the Daily Post story I read. I understand the Judicial Council has made a recommendation for 2 to go through. So we are now, is these 5 that have been shut down. It's an election year, barely 4 or 5 months to an election, notwithstanding that the justices, the nominees are good, etc. But I think the timing is bad. Let's deal with the election first, and then after that, we can come back. And then, as I mentioned, if we are going beyond 40, let's have a full debate about it. So is it that we're going to restructure the Supreme Court and have various divisions like this, a constitutional court, this is not. So there must be a debate if you are going beyond the 40.
So this has nothing to do with the competence or otherwise of these 5 persons. It's a lot more about the procedure.
Exactly. And it's good you are asking so that I will repeat. We don't want to, these are fine justices. As for Cheba, you could see that, yes, very, very independent. The rest of them, Justice Homia, these are people who have appeared before. So you can't fault them on competence. So this debate is not about competence at all. We are talking about the timing. We don't want midnight judges. You remember, even just 2 weeks ago, we were talking about the case of Marbury versus Madison, midnight judges, where the outgoing president the night before was signing the appointment letters of some judges, and then he had to lose. And so John Adams, when John Adams was leaving, and then President Jefferson, Thomas Jefferson came in. Then Jefferson didn't want to let them have their appointment letters, and then they went to the Supreme Court and all that, right? So that's where we got the phrase midnight judges. That's a judge who is appointed very close to the time of exit of a president. No, we don't want it. I think let's go on and then finish. And we can always come back to the appointments later on, after a national debate, after a national discussion, that now we are lifting the upper threshold from 14 to a greater number. And let me also quickly mention, we also follow social media and also even in some legal circles where there's the comparison that the US, over 200 million people, they have just 9 Supreme Court justices and the rest.
Yes.
It's a lot more complex. Let's just briefly mention that in the US, each state has its own
Supreme Court.
Yes, Supreme Court. Each state.
Supreme Court.
So over 50 states, right? All of them, they have state Supreme Court. So you go from the county courts, etc., up to the state Supreme Court. And then, even possibly after the state Supreme Court, some of the cases now go to the U.S. Supreme Court, etc. So it's complex. So please don't just do the 9 against 20 that we want to have in Ghana. It's a lot more complex. Let's leave that. As I've said, for me, let's do a national debate, because the African peer review mechanism as I've said, we've said it in the past. We promised them that conventionally, we've never gone beyond 14. So if now we want to break that convention, breaking the 14. So if you want to break the 14, hey, the 14 is interesting. Just like in the UK, conservatives were trying to break the 14. They couldn't break it.
Anyway, the 14-year rule ended in a very disastrous defeat.
Landslide, eh?
And anyway, but this is what the Chief Justice said. And I like the fact that, Counsel, you lay out a number of issues. Yes, competence is not an issue. The need for more justices at the Supreme Court is not an issue. It's a very legitimate demand that we have because of the number of cases at the Supreme Court as we speak. But then again, it is not because of these legitimate issues that we will do away with proper procedure and how the things need to be done in the right way, so as to even do away with the suspicions and all of this, that even now, as you've indicated, this has fed into some suspicion, if it is, that not just the NDC had, but some other persons as well, especially because of even the names in there. Justice Efias Aribotwe, fantastic judge, as you've indicated, but then again, with what is happening now, circumstances would create the legitimacy for any suspicion about why her name is there. And especially if this case turns out in a certain way, this ambulance trial. Because of everything that's happened from May 23 to date. With the revelation of Richard Jakba and so on, and this audio and how the Attorney General is involved and all of that. And to the extent that the AG is even on this Judicial Council that will have to approve these names. It's but let's take a listen to the Chief Justice.
Especially, you haven't added the fact that the judge advised the Attorney General to stay away from the trial. And yet now the Attorney General is back in the saddle, continue with cross-examination. Then you are like, hey.
So it's a bit murky. So, but let's take a listen to the Chief Justice on this.
There are several cases pending, right? That's why we need more Supreme Court judges. The discussion must be placed in context. There are several cases pending, right? That's why we need more Supreme Court judges. The discussion must be placed in context.
That's why we've done the best we can to place this discussion in context. Nana?
Yes.
You're not a lawyer, but then again, you go to court.
Yes.
So
I've gone to court a lot.
So certainly, these are issues that matters, obviously.
Yes. I've listened to the lawyers, so I think I have a fair sense of what's going on. Now, if it is the case that the law requires that it is the Judicial Council that makes the recommendation, then for me, that is the starting point, really. That clearly would show that our Chief Justice has actually basically sidestepped the law, if you like, has not done the right thing as far as the law is concerned. Now, sometimes I like quoting aspects of the Bible in some of these matters. The Bible will tell you that God is supreme. He's created everything. And He's created the law for the universe, His word. But He Himself is ruled by His law. God is not above His own laws. No.
It's divine laws.
Yes. So the Chief Justice, in terms of the authority to interpret our laws, of course, sits at the apex with her court now. But even that Supreme Court is still under the law. I mean, from a layman's point of view, I'm sure the lawyers can correct me.
Yeah, that's correct.
Yeah. So really, if that is the case, then it means that in terms of the Constitution and proper law, then the Chief Justice has not acted properly. You know, and I'm happy Lawyer Kwebu referred to a lot of the comments some of the justices, and especially one of the former Chief Justices, Atukuba, has made to the lack of confidence that citizens may have in such critical and sensitive institutions of state as the Supreme Court. Now, a lot of these sentiments of lack of confidence are quite properly grounded in our sense. If I say our, I mean those of us who are laymen, our sense of the integrity of these institutions and the way they present themselves. Now, if in the constitution of the Supreme Court itself there are doubts, there are issues of credibility, there are issues of non-legality and unconstitutionality, then we are heading into serious problems. I believe that even outside of the law and the Constitution, it is also coming out clear that just the ethical factors around the whole thing doesn't make it look good. If you have what people see as a very highly political case, in the example of Honorable Atuforson and the ambulance matter being on the front burner of public discussion, and the judge at the center of it, who, as far as the NDC and some political opponents see as being used, the court is being used to persecute a political opponent. And now this judge happens to be one of the nominees. That one alone is enough to spoil the whole discussion and to send a signal that, no, this could be up to some political gimmicks, which may not necessarily be the case. It may not be the case. But now that there's a whole lot of confusion and lack of trust and lack of confidence as far as the politics of that case is concerned, if you name this particular judge as part of it, it makes it even more problematic. So I would say that aside of the law, I think we should try and avoid the appearance of undue political influence. And I'm choosing my words very carefully. The appearance of. Because you see, as for us laymen, it might not be that there is political influence. But as soon as there is something that gives us that impression,
appears to you.
It appeared to me that there is political influence, undue. I am not saying that you can totally avoid political influence. In any case, if constitutionally the president has the authority to appoint, already it's a political process. It is something, even though it's constitutional, the president is vested with the political power of the state, the whole state. So there is politics out there. But where it begins to appear that the influence of a certain political bias is unduly being brought to bear on this process, we will forget about the substance. We will put aside the real issues and just focus on the peripherals. You know, but in any case, even in this case, there is a major case to be made for the substance in terms of law. So that is bad enough. Now, secondly, you are looking at a situation where people feel that there is some political underhand dealing. It just doesn't go to help the credibility issue of the institutions of state who require, by necessity, they require to have that credibility. People need to have confidence in, say, the police. People need to have confidence in the courts. People need to have confidence in the Supreme Court of Ghana. So if there is anything that is done to take away from that credibility and create confidence issues, I think it's a very major problem for our democracy and the institutions of democracy. Now, as for the excuse that the workload of the Supreme Court is so heavy that they need more judges.
I don't think that's an excuse. I think it's
no. Why? Listen to me. Why I say it's an excuse? Because there are ways of going about it. My suggestion, I'm not a lawyer, but I spoke to a lawyer and he tried to explain to me before I got into the studio about this. That's why I call it excuse.
Okay.
Now, if we think just a little clearly about this matter, why should all land cases end up at the Supreme Court? Why should all business cases end up at the Supreme Court? Why should all chieftaincy cases end up at the Supreme Court? Why should all matrimonial cases end up at the Supreme Court? So simply put, I am saying, this is my layman. When I had a chat with the lawyer, I told him, I said, look, so why don't you create specialized courts who have finite authority over certain particular sectors of the law, so that, say, constitutional matters and others of a certain nature and magnitude will then be ceded to the Supreme Court. Okay. Now, every single land case has the potential to travel to the Supreme Court. Every marital case has the potential to travel to the Supreme Court. Every chieftaincy case has the potential to travel to the Supreme Court. But you want to let this court possess that weight, that authority, where it deals with cases that no other persons or no other courts would appear not to have the capacity to deal with. You know, I don't know how the technical people will look at this, but I think it is quite practical. When I tried to find out a little bit about the U.S. Supreme Court, it doesn't appear to me that almost every case will end up at the U.S. Supreme Court.
Yeah. They have a sieving process.
A process.
Yeah.
So I am saying that sieving,
yes, they sieve it
yes,
to determine whether or not
it should go there.
Yeah.
So it's in there, it's received there, but there are a number of clerks. There are specialist lawyers.
So let us find a way. Let us find a way of making sure that, look, if a land case of a certain nature can be handled and concluded, and it doesn't even go beyond the appeals court, why don't we find a way of doing some of those things? Okay. This might be technical issues. This might be very highly constitutional issues. You might need some constitutional reforms to be able to restructure the whole thing. But clearly to say that because we have just too many cases, and every case is ending up at the Supreme Court, and so therefore we need to pack the Supreme Court, if you like, I don't think it's productive in that sense. It doesn't make our judicial system, as far as a layman like myself is concerned, it doesn't make our judicial system so efficient and so effective. I think we should take some critical look at the way our whole judicial structure works.
Nana, I do appreciate you on this. Thank you. And lawyer, I mean, as a lawyer and then also an officer of the court, seeing the situation that the courts are having to deal with and what the Chief Justice did, the NDC's position is that this could have been occasioned because of certain sinister motives or some suspicion that you had. Now, you juxtapose that with what you see when you go to the courts. What should be done? And why is this, the Chief Justice's letter, really a major concern?
Okay. Thank you very much. When I got freshly minted and began practice properly in 2010, completed school 2009, and now you do the pupillage. So after about minimum 6 months, you are qualified to apply for a license. So I began serious court work in 2010. Even then, you still had some semblance of merit-based promotion. I have to put it that way. Even though there were still issues. When you saw a judge being promoted, you knew that this one, you will see that purely based on merit. Because There are some persons, even then I knew of their political career, but the person got elevated onto the bench, either from practice. Even the current CJ herself, she got elevated from practice. You know, so if the authorities at the time they don't think you were of such quality to be a juristic officer, they wouldn't have if they had to consider political issues. Look, the CJ simply breached the Constitution. She exercised a power she didn't have. Okay, in this matter. And that's one. Two, even the composition of the Judicial Council have a problem. Because the Constitution is very specific, because it's a creature of the Constitution stipulated clearly as to the entities that should be represented on the Judicial Council. A representative from the chairman of the regional tribunal. The CJ has refused to implement Article 42 and 43 of the Constitution, which is supposed to create the regional tribunal system. It hasn't been done. 3, as we speak, we have 123 High Court judges. 123 High Court judges. We have 32 Court of Appeal judges. The senior most is Senyo Jamefe. Senyo Jamefe has been sitting on the Court of Appeal, if my reckoning is correct, about 14 years now. I think the next senior most will be Justice Sir Dennis. He was also brought from practice. He was based in Kumasi and got elevated onto the bench, got appointed onto the bench directly by the president at the time from practice to Court of Appeal. I think he's also about 13 years on the Court of Appeal bench. Then we have justices like Subari and Novice Ayini, you know. So naturally, if there will be a recommendation for elevation to the Supreme Court, you would have thought that you would have considered the senior most from the Court of Appeal to break the ceiling and enter the highest level. Then we bring others up. But we are having judges appointed from the High Court directly, which is, for a long time it hasn't happened, but it's happened now again. Then, strangely, let me juxtapose especially what the CJ said to justify why she thought we need more judges on the Supreme Bench. Yet you are bringing Supreme Court judges to the level of High Court matters. And yet you are complaining that you are inundated with work at the uppermost level. So keep Supreme Court judges at the supreme level. Don't even bring them two floors lower. So when a Supreme Court judge who sits as an additional High Court judge over a High Court matter and distill the law, and a party is aggrieved and it goes up, are you tackling that opinion from the Supreme Court judge who sat as an additional High Court judge as a rendition of a legal, a judicial opinion at the High Court level, or a judicial opinion from a Supreme Court mind? Is it the difficulty I have? So our own conduct is not matching with our ways. That's my problem.
Right.
Okay. As we speak, we have 15 Supreme Court judges. 15. 11115. 1111. 15. From the communique that you read, it means 2 have been confirmed and recommended by the Judicial Council to the President to be appointed. And they will be, of course, referred to Parliament for our approval. Then the Chief Justice herself, Sue Moto, proposed that 5 be also appointed. If this had gone through, that would have been 7. 7 plus 15, that would have been 22. 22 Supreme Court judges. 32 Court of Appeal judges. And the Court of Appeal, I read a bulletin recently that her decision in January has been reversed. As soon as you became a CJ, you collapse all the other regional Court of Appeals. This January. That the Court of Appeal sitting in Tamale is closed. The Court of Appeal sitting in Cape Coast is closed. The Court of Appeal sitting in Ho is closed. So all matters pending before these courts should come to Accra. And all matters pending before the Court of Appeal sitting in Tamale should be brought to the Court of Appeal in Kumasi. And then I think the one in Sunyani should also be brought before Kumasi.
I see.
But these were some of the justifications why you asked for more money, more to support your budgetary allocations. So if you have 32 Court of Appeal judges, manning only 2 branches, are we not inundated with work? Okay. Don't we have surplusage? All right? Now, understand how the Supreme Court works. So the court is properly constituted to work 5 judges. In cases where they have to deal with motions, a sole judge will preside and deal with motions hurriedly, as the Constitution determines. But 15 Supreme Court judges, at any time rotating, paneling, repaneling, and panel being reconstituted, I don't think there should be a complaint about the fact that you are inundated with work, so you need more numbers. Unless you can demonstrate that, of course, which they do, because when they come before the parliamentary budgetary hearings, they tell you the number of cases and that come. But what is the rapidity with which the matters are heard and determined? We don't know that. You are also not able to tell us that a Supreme Court judge on an annual basis handle, say, X number of cases on the average. You haven't given us those statistics to tell us that on the average every year, a Supreme Court judge hears about, say, 100 cases. So because of that, the workload is too much. So we want additional hands to lessen the burden. And finally, the political optics. When you have a Supreme Court, a Court of Appeal judge who has been serving efficiently, effectively for 14 years, and he's glossed over for his colleague who had just been promoted less than 2 years and is on her way to the Supreme Court, you have cause to worry. You have cause to worry.
Okay.
So, for me, these are the matters that are germane to this case. But the CJ completely acted unconstitutionally, and yet there will be no consequences when that happens. When the CJ acted in breach of the constitutional provision, what is the penalty for that? What is the punishment? Yes, but there's none. There's no consequence. So we'll continue to breach the Constitution with impunity.
Okay. Nelson Rossen, thank you. As a Member of Parliament for the South Dike constituency and also private legal practitioner, is a member of the Subsidiary Legislation Committee of Parliament, the Constitutional Legal and Parliamentary Affairs Committee of Parliament, and also the Public Accounts Committee of Parliament. And he's the NDC's candidate for South Dike, the 2024 elections. And he's going to have to run into another meeting, but would also have a representation from the NDC replacing him. When we get into the next issue of Dr. Matthew Poku Pempe finally approved and as officially outlawed by the NPP after the approval by the National Council, the National Executive Committee, and then the Steering Committee, all those 3 levels as well. But before we go into that conversation, Lawyer Martin Kpebu, there's been an express request from a number of our viewers, plus a family that we understand you helped for 8 years. You were in court for this said family, and you did not take a dime for that service that you rendered. And I understand that you won that case for and on behalf of that family after 8 years of going to court for them. And this is the case of the Achimota Secondary School found liable for negligence in the death of Kevin Kofi Moses. Kevin Kofi Moses, who in 2016, aged 15 years of age at the time, a promising student who passed away on December 4, 2016 from cerebral malaria. And understand that the family decided to test the law on this matter. You represented them for 8 years in court, and you did not take a dime from them. And you have won this case. So congratulations is in order for you. And I know you did not expect this. In fact, we wanted this to.
That's why, because
we wanted this to be a surprise.
We don't mention our cases here.
Indeed.
But I must say a word. Is my junior in at the firm who helped me, Marcelinus Beer. So I should be thanking myself a lot. You know, as lawyers, yes, as time goes on, you can't do every case. Yeah, if you don't.
That's how they also cut the activity.
Exactly. So Marcel is held Beer. He's held this brief from beginning to end. Okay, at a certain point when he joined me 5 years ago. So 3 years down after the case started, Marcel took over, and then he's held me to the end.
And you did not take a dime from them?
No. I said, look, let's go on and finish. But we don't always take money. Honorable, that's how come
there's another surprise. Brighter Pierre, let's do this in the next few minutes. We'll go into the NAPO issue. Brighter Pierre is Executive Director of Child Rights International. Zapia, thank you for joining us. So just a quick word on this. It was meant to be a surprise for Lawyer Matipebo for some work done.
Well,
Zapia, welcome.
Yes, thank you, Okansi. I think that if you've nailed the issues, and to start with, I really want to commend Martin for what he has done, and I feel that if there is any way to describe him at all, it would be that in law there is something that they say that a good lawyer knows where the law is, and I think that he perfectly fit into that description. And you see, I've worked with a lot of lawyers, and having my background in law, clearly it's not every lawyer that do have that, the social capacity to be able to identify laws that, can fit into things like this, but is able to do that. And I think that we want to use this opportunity to say thank you to him, and continue the good work that he's doing in the area of human rights. And a lot of people that I've interacted with, especially vulnerable people, really have that understanding of the work that he's doing. Right. So we want to appreciate him for that. Getting to him and telling him that this is the case, and he decided to take it up without taking a dime, I think that we need to commend him for that. And the case itself, let me just have a brief on that. Based on this case and how he's been able to handle it, the court has also come to a certain conclusion, and I think that within the space of child protection, we need to highlight it properly.
Okay.
For institutions to get to know what the position of the law is moving forward regarding this particular case. And clearly, the court acknowledged that, yes, the duty of care is crucial, especially where you have children in an institution. And once children enter the institution, you fully owe them that duty of care. And it was established in that case. And if you look at how the judge enunciated on those things, clearly come to the point that Ghana Education Service should take a cue out of this to be able to look at how they can cause a reform within our educational system to recognize the protection component of children. Because we listened to the judge, but the judge was clear that, look, the best interest of the child matters in all the
Right.
frameworks, especially how institutions must conduct them. So we expect that some of these things would also come to bear in terms of how they handle issues of child protection in our institutions.
Thank you so much. Thank you very much, Bright Apia, and for also coming through this morning. Yes, this is he's still in shock and surprise for this.
Yes.
It's a pleasant surprise.
Yeah, I didn't. We don't announce cases.
Yes,
we
indeed.
do in court.
But this was an express request from the family and then also from Bright Apia. So I think it was worth we doing it. But congratulations to you and your team.
Yeah, thank you.
At your firm. We'll be back shortly after this quick break. We'll get into now the NPP's ticket, presidential ticket is complete. Is the NDC losing sleep about this development? And is the movement for change also strategizing to respond to this? Especially because we don't know the movement for change complete ticket as yet. We only know Alan Chemanting. Is he going to have a running mate? How is the movement also moving forward? We'll be back shortly after this quick break. Stay with us. This is the key point. Don't go away because we'll have a few people joining us.